What's up, guys? So, as far as the update on everything that I'm doing, my next move, since I have the officer and the judge's oath of office, I'm going to report them to the IRS with the Form 211 and the Form 3949A for them being conspirators of organized crime. And I have an affidavit that I'm including with the 3949A, and I think I'm going to include the oath of office as an attachment for an exhibit, right? So right here it says, with regards to case, so I put all the case numbers for each traffic violation, which they consider a criminal court, right? Which is fraud. The individual, Burr Rodney T., Judge and Officer Nelson Eric, Corporation, Henderson Municipal Court, reported as a co-conspirator in seditious crimes against the private rights of petitioner in violation of 18 U.S.C. Section 241 and 242. They are armed and dangerous. The memorandum of points and authorities, judges sign standing orders to invest all the court cases through the Henderson Township Justice Court at the Superior Court, Nevada, Henderson Municipal Court of Clark County. Every court case shall be assigned by the court administrator a U.S. Treasury public debt number placed on the court document, including not limited to traffic citations after unknown participants in the case have received their copy of the same, but without added monetary transformation of that instrument into a financial transaction, which is the definition of securitization. All the court cases are directly deposited into the Federal Reserve Bank, QSEP. So the acronym for QSEP is Committee on Uniform Securities Identification Procedures. It is copyrighted, registered trademark of the American Bankers Association. After the public debt number is obtained, which converts the instrument into an obligation, the court administrator obtains a QSEP number. This implies only one or two conclusions: that the court administrators are knowingly committing copyright infringement violations, as well as creating counterfeit obligations pursuant to 28 U.S.C. Section 472 ET SEQ 473 through 474. Or two, that the court administrator is a member of the QSEP. Now, the court has fraudulently converted every court case into a banking financial securities instrument and manipulated the court into the creditor's position and responding into the debtor's position. The judges are normally, capriciously acting with a vested interest with insider knowledge, as well as violating judicial canon. Judges are required to act without bias and to make rulings on the merits of arguments. Instead, they are making financial investments on every case, knowing the exact meaning of every letter number applied to and now written on the face of the instrument in all cases in the form of QSEP, and issuing judgments based upon features rather than upon rule of law, evidence, and oral or written argument. Additionally, the courts are also committing tax fraud by shifting the debt created by every particular case back onto the individual who is the actual creditor / real party in interest, and then fraudulently conveying the case into an investment instrument to be deposited into the Federal Reserve Bank, which shift assets from the credit side of the transaction over to the debtor, deceptively laundered as fraudulent debt into corporate assets, converted again into the bonds, stocks, and grants, and given back to the county through the Department of Transportation or through some other discrete agency. United States, as defined in 28 U.S.C. Section 3002, Section 15A, is the bankruptcy authority of Perry versus United States 294 U.S.C. 330 through 38197 L.ed 9121, and is an obligor / grantor to the Federal Reserve Act of 1913, 38 Stat 265, Chapter 6. The Federal Reserve Act of 1913 mentioned below as was an actual private law, not public law, nor public policy, as in reference to Mr. Lewis, who was injured by a Federal Reserve vehicle and sued the U.S. government for damages. The court ruled that since the Federal Reserve and its 12 branches are private corporations, the federal government could not be held responsible. Lewis versus U.S. 608 F2D 12/39, 1982. So this is case law stated. And the thing about it, the judge, what they did was fraudulent and deceptive because he put a no-show. I appeared to court, but the thing about it, when I appeared to court, I let him know that I was the implied surety beneficiary heir of Michael Lane. He did not like that. And the fact that I was the first person named they called in the court hearing, they didn't know what I was going to say. They thought I was just going to nip it in the bud and be like, whatever, you know, I'm just going to say that I am Michael Lane, but I let them know that I wasn't. And so you try to hold me in contempt of court when you know your fiduciary role is supposed to be the trustee. Yet again, you're trying to claim to be the beneficiary so you can be able to get more money from the case. And as explained, and I read out loud all of what they're doing with that Q set for that hearing, they created 4 different bonds. So they consider you as the debtor. That's why they don't want you to be claiming the beneficiary. But they play these roles to finesse us out of our position. You know, you can't let them trick you off the streets nor play with you financially. This is all about contracts, trusts, estates, everything that you would think that you knew about court hearings or law. You better relearn this shit. Relearn it and apply it to your life so you don't get railroads or you don't get played with. I'm on their ass. They can't stand the fact that I even requested the oath of office for both the judge and the officer. Where they do that at? Y'all better get with me or get left. I don't need to hear no more comments on YouTube from people who don't read. You know what I'm saying? That's all I can say. Y'all have a blessed day. Let me also add that the judge ignored my writ of quo warranto to make it where he had to uphold his oath. The fact that I mailed that through the post office, you know, that's fraud within itself because you ignored something that was private, you know, and I sent it to your court chambers as not registered mail, but as express mail. Either way, I can report him to the UPU, you know, which is the highest form of government. So yeah, he ignored this, so I'm including this as an exhibit to show proof that he was put on notice about upholding the Constitution, and he went against his oath by not even acknowledging this. It wasn't even put on record, and I know this is private, but still it has to be put on record through the courts. Instead, he gave me what? The judge gave me a warrant, and it's not right. So we're going to see.